But at the same time, the ballot initiative introduces some less than ideal elements, in some cases weaker than existing law. For example, it creates a new and confusing exemption for sharing personal data with contractors beyond what's already allowed for service providers. It also creates a convoluted mechanism for consumers to opt out of sharing or sale. So this is one of our top priorities, to make sure that there's a universal opt-out so consumers don't have to go to every single company to opt out of the sale or sharing of their information. With more than 300 data brokers on the California Data Broker Registry alone, not to mention all the hundreds of other companies that are collecting consumers' data. If they were going to opt out one by one, that's just completely unworkable, especially given that some companies have made consumers jump through hoops in order to opt out. One data broker that sells location data made me download a separate app to my phone just to opt out once. One consumer told me they couldn't even complete one opt-out because it was too much work. So making that simple for consumers is really important. The California Attorney General's rules are very clear in that they require companies to have a global do not sell signal. In contrast, the ballot initiative mandates that companies that do not want to put up a do not sell link must honor a global opt-out, but it's contradictory as to whether other companies would have to honor that. At least some reporters and law firms are interpreting that as optional. So ideally, consumers wouldn't have to opt out in the first place, that the privacy protections would be automatic, but at the very least, this opt-out should be very clear and simple, and in the ballot initiative, it's ambiguous at best. Second, the ballot initiative improperly allows service providers to combine data received from other companies. Service providers should be working for just one company at a time. When we're talking about service providers, this could be Google, this could be Facebook, Salesforce. They shouldn't be allowed to build these huge cross-site data sets. It just swallows the rules and allows them to develop more detailed insights into consumers. And finally, the ballot initiative misses a key opportunity to remove inappropriate language from the CCPA that could allow companies to charge consumers for exercising their privacy rights. This was particularly disappointing for us. At Consumer Reports, we were able to develop consensus language with retailers in Washington State for their Washington Privacy Act that would clarify that pursuant to loyalty programs, that data couldn't be sold with third parties. So regardless of what happens with the ballot initiative, we think this is an important issue that the legislature should address. And thank you for the opportunity to speak today.
Thank you. Thank you very much for joining us. Next on the